Good afternoon, folks. Welcome, welcome. Thank you for coming to join us today. Hopefully you're expecting to be at our Care Provider Alliance webinar that's exploring the Employment Rights Bill in more detail. So we're just getting everybody into the session. I think we are good. I think we've got people in from the lobby. My name's Liz Jones. I'm the Deputy CEO and Policy Director at the National Care Forum. We are a member of the Care Provider Alliance, and the Alliance is an umbrella grouping of a whole range of membership organisations for care and support services across England, and some of them work in the devolved nations. So we have been doing a lot of work as an alliance to understand the implications and the detail of the Employment Rights Bill and to think about what is this going to mean for all of our collective members across a very diverse range of different types of care and support organisations. So today, this webinar is enabled to help you get up to speed in terms of the detail and hear perspectives from different colleagues across the Alliance who are bringing their views from the different membership bodies that they are expert in and that they lead. So our colleagues are going to introduce themselves as they come into the webinar with their particular chunk of expertise. First of all, we are going to hear from our colleagues at Anthony Collins, who are a legal firm that do a huge amount of support for our sector. Before I move on to Anna from Anthony Collins, I'm just going to do a little bit of etiquette for our session. We've got, I think, an hour and a half, so finishing at 4:30. We've got a recording underway of the session and we've got a slide deck as well. So both the recording and the slide deck will be shared with attendees afterwards. We'll be popping them on the Care Provider Alliance website, I think. Unless we think that there are some very, very sensitive questions that people wish to ask, in which case we might have to think about the nuance of that. We'll certainly be able to share the slide deck. It is really important that you feel able to ask questions as we go, and you will see that there is a Q&A function in the ribbon. For me, it's in the ribbon along the top. So we will be monitoring the Q&A and looking to answer those questions as we go. We'll either be writing answers in response or we'll be trying to pick them up in person as the session goes. I think that there is also a chat function, which is different to the Q&A function. So please do introduce yourselves in the chat. You can see that my colleague Rachel has been popping comments in the chat. So if you want to say hello, tell us what organisations you are from. That makes everybody happy because we know that we're reaching a pretty diverse audience. So intros in the chat, Q&A in the Q&A function. I am going to stop and I'm going to hand over to my colleague Anna de Beck from Anthony Collins, who's going to tell you about some of the detail of the Employment Rights Bill, which is a flagship bit of government policy and absolutely massive. So over to you, Anna.
Thank you, Liz, and good afternoon, everyone. We can skip to the next slide, then. I don't think people need to see my face twice. I'm Anna de Beck, partner at Anthony Collins. I lead our employment and pensions work, which is tailored to a number of sectors, but my particular area of interest and advice is to health and social care sector, where I've got about 15 years of advising providers, both not-for-profit, but also private providers across the variety of different services. In terms of the Employment Rights Bill, obviously many of you will be aware that the ERB was initially hailed as a vehicle for generational change. I think the optimism is fading a little bit. As some of you may be aware, the bill is about 300 pages long, yet it still lacks a lot of detail, and there is a lot of secondary legislation that will be required in order for the ERB changes to come into place. In July, the government implemented its roadmap, which offered an outline of expected time scales for the future. But I think even those are uncertain now with everything else that's going on. The bill, first of all, was intended to be law by now, but it continues to ping pong between the Houses of Parliament. So the House of Lords is resisting a number of major points that were part of Labour's manifesto, including the prohibition on 0 hours contracts. There is the approach to day one rights and unfair dismissal, which we'll touch upon, and some issues that they cannot agree in relation to trade unions and strike action. So the bill is due to return to Commons, but it's unclear whether this will happen this side of Christmas. And there is recess from 18th of December until the new year. So it's possible that it's not going to become law this side of Christmas, and it was supposed to become law in autumn of this year. What I would say is that this deadlock in the bill going through could delay implementation and could delay the proposed roadmap. Although the government is still saying that it won't, I think there is at least some chance that some of the changes that we are expecting to come in April actually won't happen. I think I've got about 20 minutes just under, and over that period of time, I want to just highlight to you the key changes that the bill introduces and we envisage will come in next over the next couple of years. So Finn, if we could go to the next slide, please. One of the major and currently disputed changes is the removal of the qualifying period for unfair dismissal. So at present, if you're not aware, employees need 2 years service to bring a claim for unfair dismissal, and the government has made it very clear as part of its or Labour did as part of its manifesto that 2-year qualifying period is unfair, and that employees should be able to make complaints to a court, to tribunal about their employers as soon as they commence employment, and not having to wait 2 years, particularly if they are unfairly dismissed during that 2-year period. It was initially proposed that therefore this 2-year period would be abolished, and instead employees would have right to bring a claim immediately, but that there would be a statutory probationary period during which employers could apply a light process to dismissal rather than a full-blown ACAS code of conduct approach to dismissing employees. Probably many of you have read news last week and developments over the last few days where effectively it's been announced that although the 2-year qualifying period will be removed, this will now be replaced with a 6-month qualifying period. So in essence, employees are not going to gain a day one right to bring unfair dismissal, but within the first 6 months, employers will be able to continue to dismiss employees in a relatively simplistic way and without a risk of litigation. The government haven't really said a lot more on this in the last few days. So at the moment, that is all that we know. We also suspect that this means that the light dismissal procedure will be abandoned altogether, and instead, as I say, we'll just have a change from a 2-year cut-off point to six months. In terms of, Finn, the next slide, in terms of how to prepare for it, I don't think that this change from day 1 to 6 months actually changes significantly how you can prepare. I would say the first thing is poor hiring decisions will be more costly when early dismissals carry greater legal risk. So I would encourage everybody to review your recruitment and retention data to spot any problems and strengthen your hiring practices. I would say secondly, probationary periods will still be very important. So I would encourage everybody to ensure that you review your probationary policies and you have robust processes and documented and consistent approach to dismissals. I think training managers, making sure that they understand correctly how to use policies and don't use them just as tick box exercises. And one point of caution that although the right to bring unfair dismissal will be limited to those who have had 6 months employment, currently 2, discrimination claims can be brought at any point. If we move to the second area, guaranteed hours. So another major and contentious change is the government's plan to introduce more regulations relating to 0-hour contracts, obviously heavily used in social care sector. And while an outright ban has been suggested, it's not gonna come in, and instead it is anticipated that from 2027, the bill will impose significant new duties on employers who use 0-hour contracts. And there are 3 main things that we expect to see. The first one is that there will be a requirement to offer guaranteed hours to qualifying workers, which will include 0-hour workers, bank staff, but also agency workers that might not be under your employment at the time. Effectively, the hours offered that you have to offer will need to reflect the hours worked in a prior reference period. This prior reference period is still to be determined, but we expect it to be 12 weeks. So effectively, whatever somebody works for 12 weeks, you then will have to replicate it with a guaranteed hours offer. As I've already said, this requirement extends to agency workers. Still a lot of detail missing. We still don't know exactly how this will look like, but this safeguard will be put in place. And the second thing will be the requirement to provide reasonable notice of shifts to qualifying workers, and again this will include 0 hours, bank staff and agency workers. And the government has not said what that reasonable notice will look like, but it looks like it will be at least 48 8 hours, and might be even more. There's been suggestion that it could be as much as a 7-day notice. And then the third change is compensation for last minute cancellation and shift changes. Again, we don't know any detail in relation to what level of notice will be given, what will be the level of compensation, but it's another way that the government proposes to safeguard in relation to 0-hour arrangements. If we go to the next slide, Finn, sorry, in terms of what you need to do or what considerations or how to prepare, I would say that the first thing is to assess the impact and where appropriate and possible, move staff from irregular hours to permanent contracts so you don't have to do the guaranteed hours arrangements if at all possible. I know many of you will have services and run care in a way that might make this tricky, but I think reviewing exactly what your workforce structure looks like, where you use 0-hour workers, and considering how you might be able to restructure it between now and 2027 is sensible. I think developing good systems for tracking qualifying workers, being able to monitor who qualifies for guaranteed hours once we know who that in fact is. And I think many providers are already investing in kind of scheduling, payroll and tracking tools to enable them to do that once these changes come into place. And then I think a third point I would make is I would be starting to engage with agencies to discuss their plans for how they propose to implement it and how you can work potentially together. If we go to the next slide, hopefully this is something that you're familiar with, but from April 2026, the 3 waiting days for SSP will be removed. So qualifying employees will be entitled to SSP from day 1, and workers earning below the lower earnings limit will also qualify from day 1 and receiving 80% of their usual pay. Obviously, this could have significant financial implications. If you haven't already, I would consider running budget scenarios using past sick leave patterns to estimate your potential financial impact. Payroll systems will need updating to calculate SSP correctly. And also, while higher sickness levels are not certain, I think a proactive approach to managing your sickness absence would be recommended. And with that in mind, I would strongly recommend reinforcing absence reporting practices, training managers to ensure they manage sickness consistently and appropriately, and then tightening monitoring of sickness absence and using tracking tools to log reasons, duration, return days, and being able to spot any patterns early. The fourth area, harassment, as you may be aware, last October, the Equality Act was amended, requiring all employers to take reasonable steps to prevent sexual harassment. And the government, through the Employment Rights Bill, is extending this and strengthening protections against harassment. And 3 key things to note is from April 2026, so just around the corner, complaints of sexual harassment will qualify for whistleblowing protection. So we'll need to update your policies in relation to that and be mindful of that. From October 2026, third-party harassment is being reintroduced, so employers will be liable for harassment by anyone encountered through work. So that can be harassment by clients, contractors, or maybe even the public. And your only defense will be if you have taken all reasonable steps to prevent harassment. So again, considering what that looks like, I think is really important now. And then finally, October 2026, the duty to prevent harassment will extend, effectively raising the bar for compliance and workforce cultures. So in terms of preparation, I would say review policies, review your training, follow the EHRC guidance as a compliance benchmark, conduct risk assessments, particularly in areas where there's lone working, night travel, power imbalances, third-party interactions, and how you're going to make sure that you've complied with all reasonable steps defense. Implement targeted action plans in relation to your particular risk areas, and make sure that you follow up on any incidents and feedback. Paternity and parental leave from April 2026, paternity and unpaid parental leave will become day one right for qualifying staff. The government also said that it aims to align paternity leave with maternity and adoption leave to address low take-up rates. So there will be further development and review, but in the meantime, in terms of paternity and parental leave, employers will need to update your policies and monitor the developments going forward. If we could go to the next slide, Finn. The other area to highlight is union-related changes. So the Employment Rights Bill introduces several changes to trade union provisions. I would highlight key three. I think the first one is statement of trade union rights. So from October 2026, you will need to provide all new employees with a statement of their trade union rights alongside their employment particulars. So that will need to be prepared and ready to go. And there is actually an ongoing consultation in relation to this, which closes on the 18th of December this year. From October 2026, unions will also be able to request access to meet, represent, recruit, and organize workers and to facilitate collective bargains. So they will actually be able to have access to your workplaces. I think employers need to take reasonable steps to facilitate access, and access will only be able to be denied in very limited circumstances. We await further details and further regulations, but that's something that you'll need to prepare for. And then the final point to highlight is that there will be a simplified recognition process. So I think going forward, it will become much easier for unions to seek recognitions. And we know that unions are really interested in social care sectors. So we suspect that many of you will be contacted, and unions will have more interest in gaining recognition within your workplaces. If we could go to the next slide, Finn, I would highlight that from April 2026, there is also a new agency being established, a Fair Work agency. Effectively, this agency will be responsible for enforcement and auditing of various employment practices. Checking compliance of national minimum wage will move to this agency from HMRC. They will also be responsible for checking compliance in relation to holiday pay, SSP, modern slavery, agency worker protections, and in the future, possibly also fair pay agreements for social care. And so my advice, kind of in preparation for the agency being established, is to audit all your relevant practices, so NMW, holiday pay, SSP, and make sure that you have all the records, and if they come in, you are able to present exactly how you arrange those things and pay for those things. And you see on the slide, the next point to highlight is fire and hire. This is effectively where an employer dismisses an employee and offers to hire them on different terms that replace the existing terms. It's a common approach used when you have really onerous terms and conditions of employment that you can no longer afford, and effectively you offer to redeploy staff on new terms. Whilst this is not illegal, it's been quite controversial, and therefore the government is changing it, and from October 2026 effectively dismissing employees in such circumstances will be automatically unfair, and there will be very limited exceptions in which that will be possible, effectively where there is a severe financial difficulty. And the rules also capture replacing those employees with another worker. So, for example, dismissing employees on those generous terms and replacing them with a contractor or agency worker who are on less onerous terms. That will also be banned from October 2026. There are many other changes that the Employment Rights Bill introduces, but I think those are the key that I would highlight to you for the time being. I also want to highlight to you a number of consultations that are currently ongoing. That's on the next slide. So we've got a few that I've picked out on. Obviously, the most important one is that there is currently consultation on the establishment of the Adult Social Care Negotiating Body. This body will agree fair pay agreements for social care. And the FPAs will apply to all staff in scope, regardless of your trade union recognition, across the entire sector. And the consultation is currently ongoing, will finish on the 16th of July. But as part of that consultation, views are sought on the scope of staff that should be covered by it, but also the remit of future FPAs. So what they should be covering. And I know the CPA are running a specific workshop on FPAs on the 11th of December. I think details will be available during this session, so I would encourage you to attend that. Sorry, did I say July? Sorry, Finn. Yeah, 16th of January. Sorry. Yeah, so there is a specific session being run on 11th of December, and yeah, as Finn corrected me, the consultation runs up until 16th of January. And then the other three consultations that are currently ongoing, we've got consultation on protection for pregnant workers and mothers, and a consultation seeks views on circumstances, in what circumstances should dismissals be allowed when we've got protected employees, whether there should be a new test in relation to that, and what should be the fair reasons for dismissal. We've got a consultation on bereavement leave, which is again ongoing, and then we've got consultation on two different trade union related matters, and I would encourage you all to have a look at those consultations and consider making submissions if they are relevant to you. Mindful of the time, Liz, I think you wanted me to finish at past, so I'm gonna finish there.
Oh, that is awesome timing, Anna. Perfect. Thank you. Thank you very much. And I can see that Rachel's popped the details about the next webinar, focusing on the Fair Pay Agreement, in the chat. Thank you, Rachel. So, as we said at the beginning of this, Anna's in-depth, speedy coverage has highlighted just how much is in this bill for us. I think the reflections that we've had here at the National Care Forum is that there's an enormous amount of potential change coming for employers, regardless of your size, in the care and support world. And of course, remember that we are one sector amongst many who are going to be affected by this legislation. I think there are some things that make it particularly challenging for us, and I'm pretty confident that my colleagues from the different membership organisations within the Care and Support Care Provider Alliance will highlight for us just how much we're going to have to think about some aspects of what's in this bill. There is one question, Anna, that I think we should pick up now, because we'll probably get some more detailed ones about the areas that our colleagues are going to cover. Joe asks, are the SSP rates going to be going up to 80% of their usual pay then? Is your SSP question.
Yeah, so effectively, what is happening is that currently workers earning below the lower earning limit are not entitled to SSP. From April 2026, they will be entitled. They will also qualify from day one. And yes, effectively, their SSP during that period of sickness will be 80% of the usual pay.
Thank you for clarifying. And I would just say to all of our folks listening, as an alliance, we have been very alert to the fact that the proposals in this bill, which will eventually pass, if it doesn't pass before Christmas, it will pass afterwards. We're very alert to the fact that this brings complexity for us as well as cost. Complexity, as Anna's outlined, in terms of the things that we're going to need to think about to be able to respond to the requirements in the bill, alongside the fact that the Fair Work Agency is going to be, I guess, a kind of combined enforcer of things, some of which are already being enforced and other of which will be new elements. And I can imagine a number of people on this call will be saying, well, that's all very well, isn't it? How are our commissioners across local authorities and the NHS going to respond to this? Because we will be the organisations with the employing responsibility to honour all of these new legislative requirements, and that is going to need resourcing by our commissioners, acknowledging in the way that sometimes they perhaps do less of. So we have now got, let me just check, I don't think there's any more Q&A just for now. I wanted to pick that one up just because it was relevant to the immediate presentation. Okay, so we're now moving into 3 10-minute sessions where we're going to hear from colleagues across the Care Provider Alliance on different aspects of care and support world. So we've got 10 minutes thinking about specialist care services, 10 minutes thinking about home care services, and 10 minutes thinking about residential care services. And in each of those 10-minute slots, our colleagues are going to offer their reflections about the implications that we're hearing, different aspects of the implications of the bill that Anna has just very ably taken us through at perfect time. So I'm going to hand over to my colleagues Victoria and Peter, who are going to give us 10 minutes reflections on the Employment Rights Bill from the perspective of specialist care services. Thank you, Victoria and Peter.
Thank you so much, Liz. Good afternoon. My name is Victoria Beyer, and I am joined by my colleague Peter Lewes for the second part of this session. Today, we're representing all 4 of the organisations within the Care Provider Alliance, whose membership comprises of the very diverse range of organisations and those we've collectively suggested as specialist services. Mainly, we mean the care and support services that are delivered for adults of working age. These individuals who are cared for by a huge amount of providers in the market require the expertise and resources to meet unique support needs. These arise from their lifelong health conditions, physical disability or social disadvantage, and include individuals with sensory impairment, learning disabilities and autism, and those with a mental health diagnosis, including early onset dementia from alcohol or drug misuse. We're really interested in the definition of the care and support worker under the Employment Rights Bill, and I'm going to read to you the legislation which defines the care worker as an adult social care role for anyone who is employed wholly or mainly in connection with the provision of adult social care in England. Adult social care is described as any form of personal care or any other practical assistance to individuals aged 18 or over who need such care due to age, illness, disability, pregnancy, childbirth, dependency on alcohol and drugs, or similar circumstance. So we're really clear that the bill definition is intentionally broad, and we think it includes all of the wide variety of roles and employers within the adult social care sector. Local authorities, those that are directly employed within care, those people that might have personal budget holding, as well as personal assistants, and all of those individuals that work for private or charitable care providers. Therefore, the Employment Rights Bill legislation includes all unregulated as well as CQC regulated service employees within the scope. Next slide, please. So as we are suggesting, essentially our service delivery across communities within specialist services is far-reaching. This visual is about the data that we've sourced from local authority expenditure by care group, and it includes information from NHS England and the King's Fund. It shows that in the over 65 category, we spend about 6.6 billion on care homes and about 3.4 billion on community setting services. So for those working age adult services, you are delivering about 3.1 billion into the care home type residential setting and approximately 6 billion into community-based care, clearly illustrating contrasting patterns of care expenditure between the two groups. We're interested particularly about how the proportion of these expenditures within the working age category covers supported living, community support, shared lives, and other alternatives, including day services. So we also recognise that the cost to deliver support to these specialist services can be higher than other areas of the social care landscape. For example, within some community settings, we have individuals with 2-to-1 and 3-to-1 staffing ratios. And so we suggest, while this shouldn't cause alarm, you are going to have to look at some of the details of the Employment Rights Bill and ask questions quickly to ascertain the impact of the day one rights that Anna's outlined. Particularly, we suggest looking at the paternity leave and unpaid parental leave. Quite often within community-based services such as mental health, we have a higher proportion of men working there, so that may be something that you particularly want to look into. Protection from harassment arrangements, do check your policies and procedures, as Anna has suggested. And statutory sick pay we'll come on to talk about in a little bit more detail. The trade union element of the Employment Rights Bill is really interesting for us. In specialist services, you may already have a positive stance on the position of access to trade unions from October 2026. In a straw poll of our members, what we found at ARC England is approximately 25% of all of our members either have individuals who are employees who are union members or have some informal recognition agreements. So you should note that union representatives should already have opportunities to access some of the specialist services that within our membership. But we do note a few things. Union representatives should not meet with employees in any environment that we would not consider to be a workplace. For example, if you're running supported living services, or you've got an individual with complex needs who might be accessing services in their own home, we'd say that this is inappropriate. Trade unions can meet your employees in a head office location or in another organisational building, and that could be one, for example, that uses or delivers day services. We do recommend, however, that you do look at some sort of training for managers who may be involved with staff and trade union engagement processes. Next slide, please. We also suggest having a really good look at the impact on the employee pay terms and costs, as we've talked about. Specialist services, their complete workforce cost on their budgets is often higher than some of the other parts of adult social care, and we know that generally costs run at approximately 80% of overall budgets. We have put this visual breakdown of the Skills for Care workforce data to just talk about the amount of roles that we believe are in the community. There are approximately 1.7 million roles in adult social care, and of those that are in the independent sector, so the care and support that's delivered outside of NHS or local authority contracts, that's about 1.3 million people. What we're saying here is that while we've got some vacancies obviously running in the sector, and those other 11% that we've talked about that could be local authority funded workers, we have approximately a breakdown of about 800,000 people in older people services and about 630,000, so an average of both mental health and learning disability services and specialists in working age. That's just under 40%. So we're really interested to think about how that proportional representation is going to be managed as we move forward, and make sure that there's clear representation for the 4 organisations that we represent, to make sure that there's plenty of parity for our workforce in the Employment Rights Bill and the associated Fair Pay Agreement. Another interesting statistic is that there isn't anything that suggests the number of specialist services that are run by charities. There's no statistical significance, but we do know that there are a lot of voluntary sector community organisations, faith-based, social enterprise and not-for-profit. And Peter and I understand from our members that a lot of our existing members' terms and conditions of service are sometimes already a bit closer aligned to the Employment Rights Bill model. For example, one of those is statutory sick pay. So the Employment Rights Bill, as Anna's explained, changes the qualifying period to day 1, and that will apply from April 2026. We agree absolutely that you do need to think about absence management, and it's an important part of preparing for the changes to SSP. But generally, our members have told us that those that are already running quite often better benefits than the current day 3 wait time, and they may find that the impact on their budget is less than other providers. Members have already shared with us as well that enhanced SSP benefits reducing that wait time from day 3. While there is a risk and there's a sort of anxiety that may create absenteeism, what we've heard generally is it does not. But again, our advice mirrors Anna's. Make sure that you review your terms and conditions, update your policies and procedures, and make sure that you are tracking absentee management within the reviews of all staff return to works that you're undertaking. Also, consider the cost implications of the new legislation, as we say. So you might find that those terms that are in the ERB, you've already got some of those benefits covered within specialist services. Make sure that you're not switching, or make sure that you switch any external benefits that might be outside of the ERB to within it. That will save you money in the longer term. And now I'm going to hand over to Peter to continue with the next slide.
Thank you. So we've talked about the range of services that our specialist provision supports, and I'm going to look briefly at supported living and shared lives, because that's where a large proportion of the work of our members is located. Since it became commonplace at the start of the century, supported living has become the default option for learning disability support. So all of the elements on the screen will impact on measures within the Employment Rights Bill, such as guaranteed hours, reasonable notice of shifts, cancellation, compensation, flexible working, SSP, and so on. So for supported living providers, you may have to rethink the ways that you achieve continuity of care and ways you provide specialist expertise, particularly in remote and rural areas, and whether terms and conditions in contracts with local authorities provide adequate payments to you for cancellations and late notice charges. The longer-term nature of provision for younger adults exposes providers to greater impacts of erosion over time from lower inflation uplifts. If you've got services provided year after year and the inflation you're getting is less than the increase in minimum wage, then very quickly the gap that was bridgeable becomes unbridgeable. Within the voluntary sector, providers are increasingly facing challenges over the legitimate use of reserves and fundraised income when it becomes charitable funding of statutory services. So I won't repeat what Anna and Victoria have already said about the reviewing work that you ought to be doing now in terms of your policies and procedures and the amounts that your staff will be entitled to under the new arrangements. But don't forget things that are easily overlooked: statutory maternity pay, maternity allowance, paternity pay, adoption pay, parental bereavement pay, parental leave and pay. So if we can go on to the last of our slides. The specialist, move on a slide, please, Finn. The specialist services we're talking about can be distinguished from older people's services by each of the factors on the screen. But characteristics are that they often involve more sophisticated and mature partnership between the provider and the people they support, and between the service provider and the service commissioner, than social care for focus on the later stages of life. Essentially, the people in our services stay longer, and you build up a different sort of relationship with them. Within the context of the Employment Rights Bill, some of the services our members provide will even struggle with the definition of worker or working hours. For example, in a shared lives service, where the person providing support shares their home with the person they're supporting or the people they're supporting, when are they at work and when are they not at work? And it raises interesting questions about trade union access to their workplace or bereavement leave when the person who has died is part of the caring team or one of the people being cared for. The arguments that 0 hours contracts are one-sided and exploitative, which is the reason for the legislation, can equally apply to the standard practices of commissioners, which impose the same pressures on providers. The ERB creates potential for workers to gain rights for which their employers are contractually excluded from receiving funding. As members of the Care Provider Alliance, we've been making representations to government about the impact of commissioning. The employee benefits that employers in this sector can give their staff depend upon receiving those resources from commissioners, especially local authority and NHS commissioners, who are positioned between government intentions and the providers who deliver the service. But we believe the impact of this is greater in specialist services where there are few self-funders, so the limitations of the public purse dominate. VODG and AMHP have produced models and toolkits for reframing commissioning and recognising the social value of the sector. Social Care Futures estimate that generates about £3.21 for every £1 invested. And on the screen, the QR codes and the descriptions lead to those reports. So finally, as providers at this time, there are a couple of things you might want to do. You want to use the information from to review and monitor the impacts of the ERB on your workforce, and that can inform your responses to the various consultations and to your negotiations with commissioners. Thank you.
Thank you very much, Peter and Victoria. And a couple of useful reminders for us there, which I should have urged everybody on the call previously, actually. It is really important to have your voice heard. There are consultations. We're working on the principle that AI might be used in analysing the responses to those consultations. So volume matters and repeating what you think matters. So, you know, just a top tip. Better to get something in, even if it's relatively straightforward, that says, no, this is a problem, or yes, but only if this happens. So thank you for that. And the disconnect between national government ambition, the ability of employers to deliver on the front line, and the role of the commissioner in between is, as ever, a challenge for us all. So thank you, Peter and Victoria. Right, Daisy. I've got Daisy.
Hi,
Who's going
Liz.
to... Hello, you're going to give us some reflections from the home care perspective.
I am, yes. Hi, everyone. I'm Daisy. If I haven't met you, I'm the head of policy practice and innovation at the Home Care Association. I'm hoping for most of the home care providers on the call, you know who we are, but just in case you don't, we are the membership body that only represents home care providers. We've got a combination of all sorts of different members within the membership, really small providers all the way through to kind of large franchise networks, and we have generalist and specialist services that our members provide. We generally, as an organisation, do a combination, the same as most of the bodies in the Care Provider Alliance, of trying to provide you with practical support, as well as acted as a trusted voice that's informed by what you think and what you're experiencing to represent the sector. And obviously, from our perspective, we firmly believe that we want society to invest in our services and what we have to provide so that we can all live well and flourish in our communities. So that's us. I hope you do know who we are. And I'm just going to tell you a little bit based on everything that Anna's told you about kind of the Employment Rights Bill in relation to home care. So I suppose when I've been out and about talking to members and talking to home care providers, what everyone says to me is, whoa, that's a lot. Wow, I feel overwhelmed. What really matters for me? What bits can I sort of pretend aren't happening, or what are the bits that I can kind of ignore, and what are the bits that I definitely need to think about. It's probably going to sound quite similar to what Anna and others, Victoria and Peter, have said, but from a home care perspective, the association has been working really hard on probably these things more than anything else. So you're being aware of the changes to the day one rights and to other employment rights is really crucial. Those things are coming up much quicker, as Anna kind of outlined, than any of the other changes in the Employment Rights Bill. So that's something you can get ahead of the curve on now. And it's really important to think about. Replacement of 0 hours contracts. So the government have been really clear about the fact that, well, they use the term exploitative 0 hours contracts, but they have been really clear they want to remove those. Obviously, in home care, we operate with many of our workforce on these contracts. Often, as members tell me, it's because that's what care workers want. But we also know that where you're commissioned by state, by the local authorities and the NHS, that those commissioning arrangements often drive kind of what you can offer staff and how flexible you need to be in their employment terms. So that one, although not for a kind of little while longer, is absolutely crucial for you to be aware of and keep thinking about. And hidden in that is kind of some interesting stuff around notice compensation for cancelled shifts for workers, which in home care, as I'll go on to show you in a minute, is really key to the way that we deliver services. There are changes to the harassment prevention, which you've heard from Anna. There is a stronger duty on you to protect your workers. And because this relates to clients and their families, and your care workers operating often on their own, sometimes on a double up shift, it's very important that you've kind of reviewed and really thought about those policies as those changes come into place, because they're also coming into place much sooner than some of these. discussions. Access to workplaces. So in the legislation, if you're a small business, so you have less than 21 employees, the unions aren't really going to be able to access your workplace in the same way. So for actually quite a lot of home care providers, this bit of legislation isn't going to be as important for you. But there are also many of our home care providers that have many more than 21 employees, and so really understanding what your duty as an employer is going to be will be absolutely crucial. And then the final one, which we're not talking about today but we will talk about at the webinar in January, is the Fair Pay Agreement, which is starting with the adult social care workforce. You need to be responding to the consultation, swatting up on what that may or may not mean for you and what it may or may not mean for your voice in terms of how you're represented in the future. So when people ask me, what do I need to think about? These are the 5 things that I think out of the 28, 30 pieces of changes to the legislation that home care providers really need to kind of keep a watching brief on. And the association, the Care Provider Alliance and other bodies are doing a lot of work to help you keep that watching brief without having to read through reams and reams of legislation and debates in the House of Lords. And next slide, please, Finn. So at the Home Care Association, my team has been doing a lot of work to try and understand what we know about the changes and what we know about the changes being important for home care. So we've surveyed members, we've done a huge piece of work on kind of what's the current status quo at the moment for workforce, whether that's recruitment and retention and some of the things we've known for a long time, or some specific things around the Employment Rights Bill. And the reason I'm showing you these is because the other question that I get a lot when I'm out on the road talking about this is it really going to affect me? Do I need to be worried? So not just what do I need to think about, but once I've thought about those things, how relevant are they to me? So here's some data and kind of bits and pieces that I thought might be useful. So for most home care providers, the changes to SSP, they think will, on average, affect between 1% and 10% of their staff group. So everyone's expecting that more staff are going to be eligible than they were before. And in some cases, it's going way over 20% of kind of increased eligibility within staffing groups. So the actual legislation is going to apply to everyone. But in home care, it sort of depends on what your workforce looks like at the moment and how they're working, in terms of kind of how much impact you're going to see. But everyone is going to see some impact of that. In terms of the guaranteed hours and the 0 hours contracts, around 60% of the membership in the Home Care Association already offers guaranteed hours contracts. So whilst everyone, I don't think there's any member that's not using 0 hours contract, at least for some of their staff, we know that there are a lot of providers that are already set up to offer guaranteed hours. Now, the thing that's really important in the legislation on the guaranteed hours for home care is 2 things. Firstly, that staff have the option to reject a guaranteed hours contract. So it is not the case that you will have to put all of your staff onto them, but it is likely the case that you will have to offer them those contracts. So that's an important distinction to make, because a lot of the conversations I've had with providers go a little bit like, okay, I think I'm going to have to do this, but I know that loads of my care workers aren't going to want a guaranteed hours contract. So what does that mean? So that's important. It's also important because you need to think about your reference period. So as Anna kind of talked through, there will be a period of time for which the guaranteed hours contract is likely to apply between. Well, in home care, the one set of 12 weeks can look really different to your care workers' next set of 12 weeks. So they're kind of the points you need to keep considering as we understand more about what that legislation would look like. Across our membership, only 8% of our members have a collective agreement in place with the union. So we are expecting that that's going to be a big change in terms of activity and recognition in home care businesses. In terms of fair pay, most providers are already paying above the national minimum wage in our membership to remain competitive. But in home care, of course, it's not just the hourly pay rate, it's kind of everything else that sits around what a salary looks like, what a wage looks like for a care worker. Next slide, please, Fim. I'll really quickly just say that one of the things we try to understand from our members is why rotas change. And you can see here that for the purpose of kind of understanding what you might need to do later down the line with cancellation of shifts and payment for cancellation of shifts, we wanted to explore kind of why it happens on the assumption that it doesn't happen often in home care because you fancy cancelling your care workers' shifts. Normally you're changing rotas because someone can't tell you that they're about to need to go into hospital, or that a care worker is calling in sick or has got to cover some childcare arrangements personally. So really this, in terms of our representation work, is trying to make sure that officials in government who are making these decisions really understand why we do these things and why that might be quite different to the kind of shifts that the likes of an Amazon warehouse might give their staff, and why those cancellations may happen. Next slide, please. Looking at the cancellations in a bit more detail, interestingly for home care, when you look at it by the breakdown of how a home care service is funded, normally for our members that are operating with private clients, most providers have got built into those contracts with clients payment for cancellation shifts. So for some of you on this call, that might not really affect you. For our providers that are mainly dealing with the NHS or local authorities, that potentially is going to be more challenging, and we will have to think about how we adapt commissioning to, if we can, to enable for this to happen. Because without those changes, it's going to be perhaps more expensive and more challenging for you as employers. Next slide, please, Fim. And I just thought I'd say here, so the Home Care Association has been doing a huge amount of work on trying to make representations and lobby government to improve commissioning and contracting as a key enabler to the things that we're talking about today. Most of what I've talked through is not possible to achieve without a different approach to the way that you have to interact with your state services, whether that's local authorities or the NHS. Generally, and we've just published our home care deficit report for the last 2 years. Generally, what you can see is that most local authorities, just for example, are barely covering the minimum price of employing a care worker per hour, let alone the minimum price that the Home Care Association sets out as being what you need to sustainably run a business in home care. So for us, none of this is really deliverable without improvements to commissioning and contracting and the funding that flows through with that. And we've communicated and made representations for many years, but particularly over the time of this Parliament, to really make that clear to ministers, because it's almost impossible to deliver a reduction in 0 hours contracts in our sector if we commission by the minute or by the 15 minutes. So that it's a really important aspect of all of this is the kind of work we need to do on commissioning and contracting. Next slide, please, Fim. Also, kind of on that point, we've looked at the fragmentation of hours, and all you can see here basically is that the majority of local authorities and Health and Social Care Trust in Northern Ireland are commissioning kind of within this like 100 to 500-600 hours per provider. That also makes it extremely difficult for you as providers to deliver kind of full shifts. It makes it really difficult for you to guarantee hours and generally it makes it harder to improve the employment terms and conditions and pay for care workers when your kind of commissioned hours and the way that you're operating with the local authorities is kind of being trimmed with the use of frameworks and other directives. So we're doing a lot of work. This is just to illustrate, I suppose, that there are more things that enable this employment rights bill to actually happen, which at the moment aren't in place and we need in place as a sector. So finally, Finn, on my last slide, because I'm conscious of time, we've talked quite a lot, you've heard from Victoria and Peter and Anna about the things that you can do. So when people ask me, can I thrive under the employment rights bill, what should I do right now, these are the 5 things that I recommend and we're talking to our members about doing. It's modelling the cost impacts. Think about what a 12-week reference period would look like for your home care workers. Could you guarantee that for them on a regular basis? Do you have the systems in place to even look back 12 weeks? Be really, really clear about how you're auditing your staff, your employment contracts, your travel time, your rota efficiency, tighten your onboarding, refresh your policies and engage with your workforce. This is an opportunity for you to you're going to have to listen to your workforce more as the unions access the workplace. So it would be much better for you to already be a step ahead and know what it is that worries your workforce, that your workforce want you to consider more as an employer rather than waiting until the unions do it for you. So there's a little bit from me. You can always get in touch if you want to talk a little bit more about how this affects home care providers. Thank you.
Brilliant. Thank you, Daisy. And as ever, actually, a number of Daisy's words of wisdom are relevant for you regardless of the type of service that you deliver, I think. So that point about modelling the potential cost impacts of some of these changes, whether that's trying to think about what it will mean around your statutory sick pay obligations, what it might mean for holidays, what it might mean for how you're going to think about responding to the challenge of guaranteed hours. Home care, I think, faces some particular challenges, but actually some of these preparations that employers can embark on now, I think will stand you in good stead. So my colleague Finn is going to join us on screen, and we're just going to have a look now at thinking about the chunk of the sector that runs residential care services. Obviously, at the National Care Forum, our focus is supporting not-for-profit organisations who deliver care and support services, both regulated and non-regulated. So care homes are simply a chunk of our members' services. But we thought, given the combination of expertise we've got on the call today, we would focus on residential care settings in terms of care homes. So,
and I think because we're over time, we might whip through ours a bit quicker, because much of what has been said it will be within our slides, and I suppose this is just to reinforce the points and kind of drive the message home, really, and get different parts of the sector thinking about how is this relevant in their context. So yes, okay, so first thing,
do you want to say who you are?
Yeah, sure. I'm workforce and research lead at the National Care Forum, so I've been working with everyone on the call you've seen so far, really, on what the Employment Rights Bill means, what the Fair Pay Agreement for social care might look like, but also trying to galvanise some cross sector cooperation on this, as well as sort of fighting for the not-for-profit corner within those discussions, and also supporting our members to understand those kind of implications. So that's kind of what I've been doing at the moment. And Liz, do you want to introduce yourself?
Yes, I did. So
Finn, okay, good.
Yeah.
Good. Okay, I'll talk to this then, and we can just whip through it. So the one of the key things to think about in terms of social care is that, and particularly in care homes, is that these are people's homes. So enabling access in residential care raises unique issues, and there's a number of things that people need to consider, particularly in the union access part of this, that we think they should reflect on. So before we go into that, it's important also to register that we are learning, and there is a limited understanding of industrial relations in the adult social care sector, and that will be scaling up, I suppose, as a result of some of the more union-friendly legislation we're seeing. We have low levels of union representation across the sector. It exists, but it doesn't exist at the same kind of scale that you might see in other public sectors, such as health or education, for example. So this new legislation on access might see that kind of unionization build, but also requests for access in services build. As was mentioned earlier, the government is proposing different rules for smaller organisations across the economy. And obviously, as Daisy said, that's 20 people employing 21 or under staff. We agree that these changes would be welcome. I think they are still being consulted on. So that is one element of the consultation that's really worth sort of saying, yes, this proposal we do agree with. The thing that at the NCF, and I suppose this is building on some of what Peter and Victoria talked about, is we within our membership have seen quite a few positive experiences of union engagement. We've heard some negative experiences too, but there is a limited platforming of those positive experience. And is it the time to speak about best practice? And is it time to support residential care providers and broader than that? Is it time to support the care sector to understand what does best practice look like when it comes to collective bargaining and industrial relations? So there's a few things there. There's one that people need to be starting to talk to their workforce. There's another that people need to understand the implications for a care home and what reasonable access might look like. If a care home is also someone's place of work, how do you square those, and how do you think about accessing things like head offices or on digital platforms? What are the kind of ways in which this will work in practice? So that's kind of what I wanted to speak to on this. I don't know, Liz, if you had any further reflections.
Yes, I mean, thank you, Finn. I do think that we've got limited experience in some parts of our sector of industrial relations. We also do need to support the trade unions to improve their understanding of the operating environment of care and support services. And whilst a care home, or indeed a supported living place, might be somebody's workplace, first and foremost, fundamentally, it is somebody's home. So it's really important that we make this distinction really clear when we're talking to the government in the consultation, and we are very clear that industrial relations do not trump the privity, security, and independence of the settings where the people that we support live. And I think that from us, that's a pretty clear line. We can have conversations with trade union colleagues, but we cannot do that at the expense of undermining people's independence and choice in the place that is their home. So let's have a look at the next slide then, Finn.
So we thought, obviously, you've heard lots from colleagues about the different ways in which this will impact the sector, and it was really helpful to have stuff from Anna and colleagues. I thought I'd just highlight three kind of things that we might not have talked about as much, and just emphasize the residential implications. So the stronger employer duty to prevent sexual harassment, etc., including liability for third party. Residential settings face risks in terms of this, and I think those higher risks you would associate with two things: public access, but also the communal living aspect of residential care. So if you're a residential care provider, assessing how you are protecting your staff from those risks is going to be key. And colleagues have talked about a number of ways. It's worth checking again with people like Anthony Collins what you can do. Their Employment Rights Bill Hub is a really useful way of doing that. So I'd encourage you to do that on that front. And then going on to statutory sick pay, obviously we've discussed its impacts in other parts of the sector, but it's just worth remembering that it'll have an impact on your operational environment and costs. So residential providers often have sort of these larger, more diverse staff groups, which could expose them to cost impacts. So it's thinking about your payment systems, your contracts, your recording of data, your absence policies, and thinking about the financial implications for you as a provider, given these kind of larger, more diverse staff groups, which may be more susceptible to the risks of statutory sick pay. Then finally, the Fair Work Agency, obviously, is going to be kicking in from April. So thinking about, well, I think it's already kicked in. Anyway, from April, you're going to be having to thinking about how it's regulating you and enforcing you. And those implications are particularly relevant for residential care providers. Are your systems ready to evidence these changes? Are your HR systems relevant, recording the evidence, and are you pulling out the relevant evidence for the enforcement regime? So it's useful to consider that. And then finally, it's just a point to say commissioners in general must understand and honour the additional costs that the Employment Rights Bill brings. And we've heard that many times throughout this. It's worth saying that across the Care Provider Alliance, we have been really making this point over and over again. The NCF has been making it, but all the colleagues on the call have been saying this, and it's welcome to hear it reflected across all of the presentations you've had. So that's a kind of whiz through this element. I'm not sure, Liz, if there's anything you wanted to add, or whether we could move on to the kind of Q&A section and discussion.
No, I think we've had good coverage of the issues, and I think there's a lot of commonality. We're just trying to bring different lenses for the different parts of the very diverse care and support sector that is out there, to help them think about the implications of the Employment Rights Bill and how to get ready. And I do think the advice from earlier on about really starting to look at how we think things might change, both in terms of getting ready to understand how our staff teams need to be supported, what better information we might need about how we expect our staff teams will respond, thinking about how we might model costs, making sure that we're having really robust conversations with our commissioners about the implications of these changes, and we're able to evidence, within reason, what these costs are going to look like. I think is really key. So I'm just having a look. So thank you to everybody.
Yeah.
Thank you, Finn. Thank you.
Can we spotlight the other speakers? So Anna, Victoria, Peter, Daisy as well, if that's possible, and we can get the discussion on there.
Lovely. Thank you. So I'm just having a quick look in the Q&A. Let me see. So there's a follow-up on the well, actually, let's go to employment rights guaranteed hours bit. So Irene is asking, how do we go about when a staff member's preference is a 0 hours contract then? I know you touched on this, Daisy, which is we have 0 hours contracts mostly because people tell us they want them. So perhaps get some input from you, and then maybe Anna.
Yeah, I mean, I'm happy to let Anna come on this, but I did drop Irene a message just to say, well, firstly, the legislation isn't in place, so you don't need to do it yet. But when you do need to do it, as we expect, it's your responsibility to offer the guaranteed hours contract. A worker can say no, And that's really important. The thing that we don't know yet, which will probably be the most important bit, is what the reference period will be for creating the guaranteed hours contract. So Anna, I don't know if you want to say a little bit more about that.
You're an expert on this, Daisy. Now you heard me speak about it too many times. Yeah, so I think Daisy is absolutely right in that there is a requirement to offer guaranteed hours, but there isn't a requirement on the individual to accept. So you as the employer, if the individual qualifies, will need to make the offer to that worker, that individual. There is still a lot of unknowns, including whether that offer is a one-off. So you just make it once if they're a qualifying worker and that is it, or whether you will have to repeat that offer every so often. The way the bill is, or the way the government has initially presented it, is that the most likely scenario was going to be that every 3 months the employer has to review who qualifies for guaranteed hours offer, make an offer to them. The individual can either decline or accept. If they decline, next 3 months, a further review is undertaken. If they're a qualifying worker, the offer has to be repeated. And again, they have the option to decline or accept. And so it goes on. There's been a bit of back and forth on this, and we don't know whether that is how it will end up, because there is strong calls to suggest that the individual should only be permitted, or should only have the option of having the offer put to them once, and if they decline it, that closes the matter and the employer doesn't have to do it. But at the moment it appears that it will be a rolling thing of offer, decline, offer, decline, offer, decline, and you just have to keep going with it. But there is absolutely no obligation on the individual to accept.
And the only other thing I would add to that, Liz, is that if Irene's asking from a home care perspective, then that reference period that Anna's talking about is what your minimum would need to be. So if your care worker worked 30 hours a week for 12 weeks, regardless of whether you knew that you had that work in the next 12 weeks, that is what your minimum offer would have to be. If your care worker only worked 5 hours a week for those each week within 12 weeks, then that would be what your guaranteed hours offer would need to be. As it currently is, we don't know whether that will change. But in terms of the minimums, it will be related to what they've had before, not what you as a business have available, which I think is quite an important distinction from a home care perspective, which is why I was saying about making sure that you look at, if you had to do this now, do you have the systems in place to understand what that looks like for workers easily? Because as Anna says, if you have to do that regularly, offer based on reference periods, you're going to want a system in place that allows you to understand what those things would be as easily as possible to reduce the burden on you.
Thank you. And then Irene asked a related question around new staff. So presumably it's the same as in our advice is that once people have started work, they will establish some degree of work pattern over whatever then is determined to be the reference period, and they then stop being a new staff member and start being a person who needs to be offered something based on the reference period.
Correct.
Yeah. Okay.
Liz, would it helpful if I just clarified the SSP question, because it seems to have been raised in the chat a few times, and I think maybe people are having difficulty understanding it. So SSP becomes payable from day one. Currently, to qualify for SSP, an employee must earn at least the lower earnings limit, which I think at the moment is about £123. So if you earn over £123, effectively you are entitled to SSP at the moment, but you're entitled to it from day 3. From 1st of April or 6th of April, it will be that if you are earning over £125 per week, you will be entitled to SSP from day 1. For individuals who earn less than £123 per week, at the moment there is no entitlement to SSP. Going forward, there will be entitlement to SSP. That entitlement will be from day 1, and the individuals will be entitled in that when they off sick, being paid the lowest of either their fixed weekly rate or 80% of the normal weekly earnings. So effectively either SSP or 80% of the weekly earnings, whichever is lower.
Thank you. There is also a question that I'm not entirely clear is being asked. Does expat on visa sponsorship entitled to SSP? I think that's a complexity about your visa regulations.
Yeah,
so I'm not sure we can answer that one.
No, I think it would need to understand how they employed. But what I would say, just because if you're on a visa and you meet the qualifying criteria, you are entitled to SSP.
Yeah, I was going to say, I assume that. So we've got a final crystal ball question. Do we anticipate any delays to April 26 changes if the legislation is struggling to achieve final approval at the House of Lords? Well, I mean, from our point of view, once it's approved, then presumably all of the measures in it will apply from the date intended. However, I guess so we're anticipating it will get final approval at some point. It's less clear that it will happen before Christmas now. We know the government is still planning to bring in the changes that it is able to get in place through the bill when it becomes an act.
I think we have been saying to governments to the civil servants that their timetable is getting increasingly tight, that the period between consultation and implementation is getting very short, and that the fee uplift negotiations for next year are going to be well advanced before this actually goes through. I think these are all things to bear in mind when you're negotiating your 2026 fee uplifts with commissioners. I think you should be asking them to demonstrate what provision they have made for the new burdens. And if they hide behind a not yet the law response, hold on to that answer, because that could be justification for seeking a further uplift if and when it does become the law.
Absolutely, Peter.
I think also there's some things where they've already prepped themselves to make the changes. So even if the bill was delayed until March, for example, they've already consulted on the statutory sick pay changes and those are happening. So they would be able to pass that legislation and implement that very quickly ahead of April 2026. So for some of the more complicated things we've talked about, the 0 hours, the fair pay agreement, those are going to likely be delayed for as long as the legislation's delayed. But if they can pass it as primary legislation before the April, which I think if they don't, they're going to have some serious issues, then some of the things like SSP will likely still come into place because they've set themselves up to do that very quickly. But Peter's point about thinking about all of these costs in relation to your fee uplift conversations are so important.
Absolutely. Yes, I agree. I think some measures in the bill are more doable from a government's sense of implementation point of view. Of course, local authorities will also have their view of what is implementable and what is affordable. So the conversation about actually making sure that our commissioners and our NHS colleagues are fully au fait with all of the requirements that the Employment Rights Bill will bring once it's become an act, I think is probably one of the best bits of advice we can give you at the end of this call. So thank you everybody for joining us. Thank you to our speakers for their insights and their expertise. We really appreciate all of your help and support. And thank you to my colleagues across the Care Provider Alliance who've been flying the flag for discussions with government to try and bring the realities of what it's like to run a care and support service to the heart of the conversations about how the Employment Rights Bill ambitions might actually play out. So thank you, everybody. Thank you for joining us. Look out for the recording and the slides, and we will see you again, hopefully, in a couple of weeks. Next Thursday, I think, is the next one on the Fair Pay Agreement, the 11th of December. So get your place booked, bring your biscuits and your cup of tea, and we'll see you in 10 days' time. Thank you very much. Take care, everybody.
Bye.
Thank you.